Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. Good to see you. We have one case on the docket today, State versus Maddox. Is the petitioner ready to proceed?
Yes, sir, Your Honor. Good afternoon. Steve Woods on behalf of the state. I would begin with prong one, the essential requirements of law. Beginning first with Scarborough, this is a case where we maintain this is clearly the application of the law, the incorrect law was applied. Scarborough, you have a case in which the third district said the description of the injury was proper, the displaying of the scar was proper, the need for treatment was proper. This case was considered by the trial judge, and she took this to mean, apparently that simply everything had to be excluded. The error in Scarborough had to do with admitting the nature of the medical treatment. This is a case in which the police officer had been bitten, and then there was hepatitis of the victim, and this was there was a motion in limine. It's not stated in the case, but it's implied that it's a 403 issue, and it was excluded, and that came up. And on appeal, the third DCA said, well, the exact medication and tests were not relevant to the pending charge. The pending charge in Scarborough was not the pending charge in this case. The pending charge in Scarborough is 1A1 under the battery statute, which is the intentional and actual touching that's unconsented to. In this case, the prosecutors maintain that he can proceed under that as well, but this case is primarily about 1A2, which is the intentional causing bodily harm. So this is a case that is simply inapplicable, and the state would respectfully maintain that the trial judge completely got this wrong, that this was the application of simply the incorrect law. Of course, it's a petition for certiorari, so we have, the burden is, for the petitioner, it is.
Well, counsel, on that, what do you consider to be the standard? Is it just the regular old cert standard that would apply in a civil case, or do you think it's different because it's a criminal case and the state is following the petition?
Well, I know of no case law indicating that the civil and the criminal case law is different. The prong one, the departure from the essential requirements of law, for the state, I believe it's a burden we can meet because there are cases saying the Allstate case says that it is, it can come from case law, it can come from a statute, it can come from a clearly established principle of law. And throughout the hearings, the trial judge says repeatedly, Scarborough guides this case. This has said something, I think, at least 3 or 4 times. I know it was in the record on page 382 and 384, she repeatedly goes through this and talks about how her trial will be guided by Scarborough. But again, she took Scarborough to be the opposite of what it actually means. Scarborough admitted the evidence of the injuries, which is what we are saying should have happened. So again, Scarborough said, it has this sentence where it says all of this was perfectly appropriate, and it's talking about the description of the injury. This man who got on the stand and displayed the scar and stated that he needed treatment. The only thing that they couldn't do in Scarborough, the problem was that the officer testified to that he had to be tested for hepatitis C, and he had to take these very serious medications. He had to take penicillin and AZT, and that was not relevant to the particular charge in that case. And again, the particular charge in that case was not.
Let me ask you about this. These records all deal with and it's a terrible case. It's certainly unfortunate for the victim.
Yes, sir.
But the injuries are from the head hitting the concrete, right?
Well, that is unknown.
My understanding, these are not like X-rays showing a broken jaw. If that were the case, it would be an ag battery case, I assume.
Well, they could have, Your Honor, the state attorney could have charged it as a felony battery.
But he didn't, or she didn't. So it's not an ag battery case.
It's not.
And my understanding is these are not medical records from the immediate impact of the punch. Is that right?
Well, The short answer, I suppose, is that is unknown. Our response to that would be under 1A2, it is intentionally causes bodily harm to
I
another.
understand that.
So
Yeah, we know
directly
what-
or indirectly.
yeah, we know what A2 is. So
Yes, sir.
it's intentionally causing bodily harm. So clearly, for example, if these were medical records of a broken jaw, let's say for whatever reason the state attorney undercharged it. I'm not saying that occurred here, but if
Yes, sir.
that were the case, the x-ray of the broken jaw would obviously be relevant and admissible. But I'm wondering here if the argument isn't more along the lines of almost like the Paul's Graft tort case. Remember that one from law school? And so
Vaguely.
you're talking about, as I recall, something falls down and the accident causes another incident.
An
In other words, the
unforeseeable-
head hitting the concrete, those are the injuries here, right?
Well, we don't, that's not been established. We don't know. I mean, he was hit so hard that he had this cracked molar. He was hit so hard that he had a herniated disc. He had a skull fracture. I mean, the skull fracture presumably was from hitting the floor, but again, causing in 1A2 is causing directly or indirectly. It doesn't say a direct cause. So he would be
Well,
guilty.
but we're here on an extraordinary writ petition, and
Yes.
isn't the burden on the state to show exactly why this kind of evidence is relevant and why it wouldn't be enough to show either that his molar was knocked out, or to bring forward in the hearing that you needed this evidence to show, or you had evidence that showed that the hit actually caused the damage directly, that the impact of the punch caused some sort of injury.
Well, I'm not sure I understand the question. So
Well, you're dancing around the idea. It's like, well, we don't know what this medical evidence shows, whether it showed the impact, the injuries that occurred after hitting the floor, or whether it was an injury caused by the actual punch. It's just very fluid. And so I'm curious, in an extraordinary writ petition, doesn't the state bear more of a burden than just saying, well, we really don't know where this evidence falls?
Well, I mean, the burden, all the state has to show is a departure from the essential requirements of law, material injury, and no adequate remedy on appeal.
Well, and there's one more thing. You have to show a miscarriage of justice, because there are cases that say departure from the essential requirements of law alone is not enough. It's our discretion, and what we're looking for is a departure from the essential requirements of law that result in a miscarriage of justice, or what in the vernacular, the error has to be really, really bad, basically, and really, really bad for the state. So much so that we're going to intervene in a criminal case, interlocutory, and quash a county judge's order on a motion in limine.
Yes, sir. Our position would be that, as you say, it is really, really bad. This would be a gross miscarriage of justice. I mean, you have the evidence of the injuries. This proves the amount of force used, which is another way of saying, the nature of the act itself. And we need that to show intent. We need to show it culpable negligence. Without that, there would be no way for people on the jury to know what exactly happened.
Well, you accept that at the hearing, the ASA tells the judge, all the witnesses will say he cocked back and he reared back and hit him as hard as he could. The state believes that will be more than adequate circumstantial evidence for the jury to decide consent, and not that the defendant intentionally caused harm to Mr. Mauricio.
Your Honor, it could be. I mean, I suppose the response to that is, in a case like this, of course, it is better to have scientific evidence. It is better to have physical evidence. This is a room full of, this is a room full of fraternity guys who believe it a good idea to execute this scumbag of the week custom and hit someone in the face. That there are some credibility problems with these witnesses, and the superiority of the physical evidence, I think, is very important for the state.
But how does that evidence actually go to credibility of all the witnesses, including the victim? Are going to say that the defendant hit the victim as hard as he could.
If they
And
do.
there's how does this evidence that you want to get in, how does that help,
The state
resolve the credibility, some sort of credibility determination?
Well, I mean, of course, the jury is free to believe or disbelieve every witness and any witness and every witness. There is no question with these. If you had the physical evidence and if you had the scientific evidence, there is simply no basis on which it could be doubted. I think these witnesses, these is a group of a large group of approximately 20-year-old men who were engaged in this custom, and you don't know how that's going to be received at trial. The state would be deprived of something very important, and what this judge did was her interpretation of Scarborough, which she completely said, you know, I rely on this is guiding this case. She simply got it wrong. Under Scarborough, this should have been admitted. She took Scarborough to mean, you know, this paints with a very broad brush, and Scarborough is saying, well, if it is relevant and not otherwise inadmissible, then it comes in, and if not, it's excluded. So Scarborough admitted certain things that I went through before, and it excluded others. It was not the broad brush that she talks about. There's nothing like that in Scarborough. That was just from the trial judge's reading of that case, and that case was so thoroughly misread by the trial judge that this is an application of the incorrect law. So this is a departure from the essential requirements of law, is the state's position.
But what is the serious injury to the state's case, I guess, is what I'm trying to understand. Let's assume for a moment, and my reading of the hearing is the judge understood what relevancy is and understood what 401 is and understands what 403 is. And it sounds like the quibble is over whether she applied it the correct way. But aside from that, for a discretionary writ, what is the state's argument as to why this is so bad to not have this kind of evidence admitted, so bad and so harmful to the state's case that we should intervene through an extraordinary writ? Yes, sir.
Well, I mean, first, with respect to battery, we have to establish bodily harm. With respect to culpable negligence, we have to establish personal injury. The injuries prove the amount of force used. They prove the nature of the act.
How does it prove the amount of force used?
How do the injuries prove?
Yeah.
Well, I mean, as a matter of experience, how would I put it? I mean, the aftermath proves the nature of the causal event. I mean, if someone were hit slightly, they would have very slight injuries. If they had injuries...
Yeah, but you just said that the evidence, you don't have any evidence that connects the medical stuff to whether it was the impact of the punch or the impact with the floor.
Well, either way, he was hit hard enough to be knocked to the floor.
Well, then one doesn't necessarily fall from the other, because there's some testimony from witnesses that, well, he was standing after the punch, and then he went unconscious and fell over. So what is the medical evidence easily could just show, well, the impact once he hit the floor, which could have been caused by him just losing his balance after he went unconscious. But there's no dispute that he went unconscious because the punch was so hard. So I'm still not understanding why you need the medical records to show the extent of his injuries if all the evidence that you have shows that he was hit really hard.
What's your burden of proof at trial?
Well, proving each element beyond a reasonable doubt.
And isn't that the highest standard of proof required in the law? And isn't it a fact that the jury would need all the relevant information to determine whether the state met that burden?
Yes. Yes, sir. That's much better than what I was. That is far better than I put it. The intent.
So the state doesn't have to show actually or explain in any detail why this is actually harmful to its case. It's enough to just say, well, we have the burden to prove beyond a reasonable doubt. And
we have to show material injury. Yes, absolutely. I mean, material injury would be the second prong. The material injury. I mean, it's material injury. We have to show under the culpable negligence would have to show reckless disregard. And the injuries reveal the nature of this act. It does prove reckless disregard. It proves an entire want of care. We have to establish the injury. And with respect to the battery, we have to establish the intent to commit bodily harm. So if he even if this was caused by his head hitting the floor, he was still hit hard enough for that to happen. The injuries of, the
So
cracked skull.
without the records, tell us how the trial's going to play out. Remind us, are all the records excluded?
Yes, that all of the records would be excluded if we can't have.
Yeah, you don't have to show it to us. But, so all the records are excluded, so what the jury's going to hear is, I consented to the punch, because that's part of the scumbag of the week tradition,
Yes, sir.
and he punched me, and the next thing I know, I was unconscious.
That's what they would hear from the victim, something like that. Yes, sir.
Under the court's ruling below, that's all the jury gets to hear, right?
Yes.
Wait, the jury doesn't get to hear the witnesses testify that he was unconscious on the floor, they ran him to the emergency room, that his tooth came out. That's all excluded under the order as well?
Well, yes, the tooth coming
It
out
is?
would be the extent of the injury, the severity of the injury, the permanence of the injury. That is what is in the motion in limine number 1. So yes, I mean these injuries are crucial because they.
Because isn't the whole argument of the respondent here? The whole argument of the respondent here is, look, and we see this a lot in the criminal law, and the Supreme Court has made it, I think, crystal clear that this is not the rule of law. We don't review the state's evidence by whether they needed to introduce the evidence. It's whether or not it's relevant and not prejudicial under 403. So the whole rationale of the order is, as I understand it, look, you have enough. You have people to testify that he punched him hard, and so you can just have those witnesses talk about, as you pointed out, the respondent's fellow fraternity members, how hard he punched him, and send the case to the jury.
We could, but we would have him. I mean, it would significantly impair our ability to.
I guess
present
one
the case.
critical question is, what about the evidence that he was rendered unconscious? Was that excluded?
Well, that is not an injury. That is not the extent of an
That
injury.
wasn't my question.
Well, under the motion in limine and under the order, no.
That's not excluded.
No.
So, and I'm trying to present this in an objective manner, my questions. So what the jury's going to hear is, he got punched really hard, he was knocked unconscious, and so we're asking you, ladies and gentlemen of the jury, to find beyond a reasonable doubt that he intentionally inflicted bodily harm or was culpably negligent.
Both. Yes.
That's the case, without this evidence.
Yes.
Okay.
And I'm assuming the victim would testify that he signed up for this scumbag of the week procedure, but didn't sign up to get hit as hard as possibly the person could do.
He has said he consented to a touching, which of course is not consenting to any touching, as has been written about.
I neglected to recall, did you ask for rebuttal time?
I didn't realize how little time I had left. I'd like to reserve the rest for rebuttal. Thank you.
I thought so. Thank you.
Thank you.
Please support. I had to use it. They said it was there. so.
Absolutely.
Good afternoon, Your Honors. Joe Bodiford and Gannon Cohens on behalf of Oliver Walker. I wish I was here to talk about Ms. Fallscraft at the train station and the weigh scale falling on her, because I probably would be proud to say that's the one thing I remember from law school. The thing that is most concerning about this is that the state is trying to undo what Judge Ashenafi Richardson did, which was to protect Mr. Walker's right to a fair trial. And she did that.
So your argument is it's a 403 ruling?
It is a 403 ruling. She followed the law. That would be the essential law, would be 403. And if you read her comments,
So you're conceding that it's relevant?
I would concede that some injury is relevant, because they do have to prove bodily harm. I mean, and I think what Judge Thomas said about being stricken and falling on the floor and being unconscious and having to go to the hospital. Remember, and this is what's weird about this, we don't have a definition of bodily harm. We have a definition of what great bodily harm isn't, which, you know, we're famous in Florida for defining things by what they're not. So it tells us that it is I always forget the one, slight, trivial, minor, or moderate. Getting knocked unconscious on the floor and going to the hospital certainly qualifies as bodily harm. We were essentially ready
So
to
the order
concede that.
So the order allows all that to come in, that he was knocked unconscious and taken to the hospital?
Yeah, yes, Your Honor. Our motion was to take out all of this massive, there was cranial injury, he's in rehab, he's, having to learn how to eat again, because when you get to that point, then, as Judge Ashkenafi went through, then you start to get into the inflammatory part of it. And what's interesting about the Scarborough case, if you read what she did, she struggled. In fact, she even made the comment, I want to do what the Scarborough court did and try to carve out what needs to be done. And that's when she sent, and since I was the defense attorney, I'll just speak in first person, that's when she sent myself and Mr. Cohen's and Mr. Bevel into caucus to try to work it out. And over, a lot of talk about baseball and fishing and hunting, we were unable to reach a conclusion, because although we tried and met, he wanted it all, and I wasn't going to agree to all. And we even told the judge, we'll agree that we'll stipulate. Mr. Mauricio, were you injured? Yes, I was. And that is checked, and then they can move on, because the issue in this is really what was intended. This is a episode of Jackass gone bad.
The standard 403 analysis in death penalty cases and all those kind of cases, the Supreme Court has generally said it all comes in. I mean, in the death cases, for example, you've got reams of case law where a defense counsel tries to say, oh, we'll stipulate to the cause of death. We don't want the autopsy to come in. We don't need all that to come in. We'll stipulate that, he was shot and he died, and, the Supreme Court always says no. That all comes in. It's very, very rare, extremely rare, for the Florida Supreme Court to rule that autopsy photos or other types of evidence of injuries are not properly admitted.
But death is different. And we know that in those circumstances that prosecutors are going to have to prove malice of forethought, cool, rational time to plan and think about whether they're going to kill somebody. Even the cases that were cited in our briefs going back and forth, there was the case where, and I could get the cite off of it, where there was evidence allowed that the guy, the defendant, right as he was about to shoot, actually took a double-handed grip on the gun. And the defense is like, yeah, we don't need to hear about all that. And the essence of it was, well, that goes to showing how the murder, the intent behind the premeditation to kill occurred. So death is very different. State chose misdemeanor battery. And this is what is alarming about this, is that they took what is, without conceding any guilt on Mr. Walker's behalf, but I think we even mentioned in our brief the fact that everybody in that room might be guilty of culpable negligence on some part. But they've taken culpable negligence and battery and charged him at the same time, and now they're trying to mesh them together. And so we've got this, let's take the injury and show how horrible it was and work our way backwards to this lethal force, and then work our way backwards to extending the scope of battery. And I would love to talk about the scope of consent and how they're trying to extend that to go back to what his intent was. And that's just not what misdemeanor battery is. It's either intentionally cause bodily harm, hit, fall down, hurt head, maybe tooth rolls out, go to the hospital, prima facie case, or touch somebody without their consent. And that's their problem. That's the state's problem in this, is that Mr. Mauricio went up there, by all accounts, shook hands, gave a thumbs up, and stuck his jaw out. So the idea that he didn't consent to all of that, that's why we have culpable negligence. That's why you would charge that. When you take two lunatics who are going to do something as incredibly dumb as what we see on Jackass or Ridiculousness or at frat houses, you say, well, this went really wrong, and you should have known it was going to go wrong. And that's why we have gross and flagrant and all the things that culpable negligence is about. And so That's the problem in this, and that's why we fought this so hard, because in the trial court, it was a question of, we're just going to try to, turn all of this consent and injury and everything and make this, we're going to reverse engineer a crime. And that's the problem we're having with this. And I think Judge Thomas, your assessment of what the evidence would be at trial is about correct. But I can't say that there wasn't some bodily injury. There was. We were willing to concede that there was a bodily injury. We'll stipulate, we'll write it out, we'll sign it. He had bodily
Well,
injury.
you're not pleading guilty.
I'm sorry?
You're not pleading guilty.
No. We're not pleading guilty. But see, beyond there being bodily injury, there's still did he intentionally do it? So all this comes back to intent. And that's, again, what this fraternity hazing.
Doesn't that question of intent make the medical records relevant?
No, by no means, because it's the act that evidences intent. The injuries don't evidence intent when you're dealing with misdemeanor battery. When you're dealing with aggravated battery, when you've got to intend that injury happen, then I could see it becoming more relevant, but not at the way they've chosen to charge Mr. Walker. They're stuck with, did you intend to cause a bodily harm? Yes, but then, save in felony battery, it might be relevant, but 403 still kicks in. And in the course of, and now so you've got to juxtapose what the prejudice is, sir?
I guess the question is, then, does a 403 ruling that prohibits the state from introducing relevant evidence because it's too much, it goes too far, it's, as many trial judges like to say, yes, it proves too much, because it's going to convince the jury to convict on the basis of what? An uncharged crime? Well, he's charged with causing bodily harm. So how is this prejudicial?
I think the answer to that comes from the circumstances of the case. We're not dealing with
Because remember, all relevant inculpatory evidence in a criminal case is prejudicial.
Everything is inherently prejudicial.
Right.
I got you, and I accept that. I've been doing this a long time, and I get it. And I'd really love to find those judges that say that it's too much. I'd love to find them.
Well, apparently you found one here.
I think so, and I respect her ruling. The circumstances of this case, this is not a situation where someone has broken into a home at night under the cover of darkness with some very malicious and evil intent to do something horrible to somebody. This is not a case, much like we just saw the conviction in federal court last week, where the lady plotted with an undercover FBI agent to have her husband murdered and left money at Cascades Park to get picked up. This is a bunch of fraternity brothers. This is a bunch of kids for all intents and purposes. And they're doing something that is unfortunately been a problem. You could call it a tradition. Some of us might call it a problem for a long time. And so when you then put into it, and this, what was supposed to be a harmless prank, caused brain damage and caused this, there's parents on juries who are going to go, well, if that was my child, I'd want to see Oliver Walker under the state prison. And they then forget that Mr. Mauricio was just as complicit in this happening as was Mr. Walker. That is the concern that we have about the prejudice, that it will be indeed too much when we're dealing with misdemeanor battery. So that's it. That's the gist of, I think, why the prejudice comes out.
So to go back to my original question, so you are conceding that the medical records are relevant to the charge? It's
No.
just that you don't like them.
No, well, I don't like them. I will concede
Right.
that. But
because and the reason I'm asking is because you're continuing to talk about 403,
Yes.
which in order to talk about 403, you have to concede relevance. And I was under the impression, reading at least some of the hearing, that you were contesting relevance as well. And I thought that actually the trial judge also was a little bit concerned about relevance. And even the ASA was talking a little bit about relevance because the ASA, well, we'll get to that in a second.
Right. I think I know where the disconnect is, and it's not highlighted a lot in the arguments below. You do see some of it, which is contained in the record, the investigative report and the probable cause affidavit. There's some testimony, and again, having been, I don't want to speak outside the record, but having been there, I can say that the slap occurred, and then the theatrics occurred of, oh my gosh, I've been hit. And then because of the theatrics, the fall occurred, and then the head injury occurred. So there's that intervening little weirdness there of, well, was it the slap or not? So if we don't know, then I cannot concede that it is totally relevant. But some bodily injury has to be.
Yeah, and I appreciate your honesty. It has to be relevant. If it's not relevant, then the state certainly loses on a petition for extraordinary relief.
Some of it is relevant.
I mean,
not all of it is relevant. Does that make sense?
Well, which part's relevant? Because we're talking about the medical records primarily. So
I would say the medical records are not.
Okay.
The medical records of cranial issues and neurology and therapy and all that stuff, that is not relevant.
Right. And isn't that what the petition's about? I thought that was primarily what we're here for.
Yeah.
So why did you open by, why are we talking about 403 when we should be talking about relevance?
I like 403. I don't know. I thought it'd be good. No, but you're I guess you're right from the standpoint of my concern is that because the word bodily injury is still in the statute my client's been charged with, I still have to contend with that. So the argument was, I know that this has to be met, but what happened in the house versus what happened in the hospital are two different things. So that's what I'm getting at. And we're focused on the hospital records. We're focused on all that. That's not relevant. That's not relevant.
How is that not relevant to the physics of the punch? I mean, the medical records didn't result from the person punched being in a car accident.
No, but they might have resulted from him pretending he was hurt and falling and intentionally throwing
But
himself on the
isn't
floor.
that a jury question?
Whether he did that or not would be a jury question.
Right.
Yeah.
I mean, so if your argument is, and I appreciate your argument, but if your argument is, look, or maybe this is going to be your trial strategy, he exaggerated the impact of the punch, and he was horseplaying, and he tripped as part of that horseplay, and he hit the concrete, and now he has these severe injuries. Hopefully they're recovered by now, I hope. He has these severe injuries, and they had nothing to do with the punch. That's your argument, that's your trial strategy,
If
right?
that's the trial strategy, then they're not
Well, it sounded
relevant.
like it was
Yes,
from
then
what
they're
you
not
just said.
relevant. Right. Well, the trial strategy also revolves in great part around the fact that there was no intent to cause bodily harm, and it was a consensual act. So, not getting too far afield of where we are, but that does bring into question the issue of culpable negligence, and that's something that we have to contend with.
Well, and here's
It
what.
sounds to me like you're conceding relevance, and you're making a 403 argument, as you said earlier, which I totally understand, because I think that's what this ruling has to be. It has to be a 403 ruling, because it, at least as I might see it,
Well, let me
it's
be
clearly
very-
relevant. It's clearly relevant, because otherwise, the severe injuries didn't happen in a vacuum.
Agree.
He didn't ram his head in the wall.
But I want to make myself 100% clear. I'm not conceding that the medical records are relevant. I am not. I do think that the stuff that happened in there, that he did suffer, as you said earlier, he fell, assuming that's what their evidence is going to be, he fell, he was knocked unconscious, that's bodily injury, period. We're there. We don't need to go any further. So this is not relevant.
Why? How is it not relevant to whether or not your client intentionally inflicted bodily harm?
Because force is not a element.
But
And intent,
but intent focuses on what he intended to do. And isn't sufficient force to knock somebody to the ground, sending them to the hospital, and inflicting a brain injury? Is that not relevant to intent?
the first two are, the third one's not. It's the act, it's not the injury. So a haymaker coming out of Missouri and popping you right of it, that's all the jury needs to see is to be able to judge intent. What happened next? Because you could smack somebody, you could hit somebody as hard as you want to and not hurt them. Conversely, you could very delicately poke somebody's eye and permanently injure their eye and cause great bodily harm. There's all kinds of non-force touchings. And I made the analogy about, if they're doing a prank and I throw cayenne pepper in somebody's face and they die of an allergic reaction. There's no force there at all. It's the act, it's not the injury. It's the act that evidences the intent. The resultant injury may be unintended. So if the resultant injury is unintended, you cannot measure it to judge the act. You got 40-something people, they're going to say, he reared back and smacked the living daylights out of him. That's all you need to know as to whether, and this is, so that was my point about when we get to whether this guts the state's
It
case.
almost sounds to me like your argument is, and the ruling is, this evidence is too relevant.
No, to the contrary.
Because I just don't understand how the injuries resulting from the punch are not relevant to whether you intended to cause harm. If your example, if somebody just barely touches somebody, and for whatever reason that person is hypersensitive, and then the argument is, no, that's not relevant because I have witnesses, I barely touched them, that there's no way I could have known or intended to cause those kind of injuries. If the evidence is, I punched somebody as hard as I could, and I guess I'm a pretty good puncher because I sent them to the hospital with a brain injury. Isn't the jury entitled to make that decision?
They are, so long as that they, well, I won't go down that road. Think about, and we talked about false craft, and I don't remember the case where the judge came up with the eggshell plaintiff concept. You take your plaintiff as you find them, sort of thing. Well, that doesn't contemplate you take your plaintiff as their injuries define them. No, it's even in civil law that we learn in law school. It's about the act. It's about what happens up until the injury is, unfortunately, largely irrelevant. If the act evident, it's the act. It's not the injury. I could not make that any more clear. You know, if we could go through a gazillion analogies as to you look at somebody and you go, I know exactly what you're thinking by what you did. Actions speak louder than words. And so that was the gist of the great deal of our argument. We don't need to look at the injury. If we were talking about felony battery, if we're talking about aggravated
the case
battery,
law
yes.
is overwhelming that the standard is not whether or not the state needs it.
Right. Can we talk about the case law a little bit? And that has to do with the fact that this is an extraordinary writ. So let's talk about the other part of the cases that talk about what the state has to meet to succeed on a petition for cert. I mean, the relevant stuff is interesting, but at the end of the day, it's not enough for the state just to show that there was error. It has to show that there was serious error. And what I'm curious if you could just comment on, it seems like the first part of the hearing when the state was defending against your motion to dismiss, they took one position. And then when it came to the motion in limine, they took a different position. So let me just read you a quote from the ASA, you'll probably remember, and ask whether this rises to the level of seriousness of error. So the prosecutor says, if I'm going to show that he intentionally caused harm, the circumstantial evidence in this case that I have is the force which was used, which all the witnesses will testify, you know, he cocked back, he used a closed fist, the sheer force that was used, all of that. So it sounds like in the first part of the hearing, the state is saying, I've got all this evidence that shows the force that was used. That's what I can use, you know, circumstantial evidence, that's what I have to prove the case. The second part of the hearing is, we can't prove our case unless we have these medical records.
Right. They can prove the case without the injury.
So if we're reviewing this and this back and forth about relevance, maybe the judge, reasonable minds can disagree. Maybe the judge, a different judge looking at it would say, yeah, it should have come in. But that's not what we should be asking. Isn't it what we should be asking is not just whether she got it wrong, but whether it caused significant harm to the state's case and the seriousness and the procedural defect in the hearing that we should intervene.
This thing says I got 10 seconds. May I have another
I'll
minute?
extend your time by 2 minutes.
Very well, thank you.
And we'll grant the state to an additional 2 minutes.
Very well. The case law talks about it, and I guess we'd be looking at Jones, which discusses the Pettis factors, saying that it has to result in a miscarriage of justice, and it has to substantially impair their ability, and it should only be granted when the error is very serious. That's what the case law says. They can prove this case without the injuries. They can prove both culpable negligence, I'm not conceding guilt, and misdemeanor battery without all of the medical records that followed. I firmly believe that. They can go forward and have people talk about the force, they can talk about the circumstances, and all of those things.
In fact, I would go so far as to suggest that if we engage in just sort of this discussion, well, was it relevant or not relevant, it should have come in because it, all relevant evidence is admissible, we may not even have jurisdiction to address that, because that sounds a lot like a direct appeal, which we're not allowed to do.
I agree. Yeah, we talked about the jurisdiction problem earlier today, Mr. Cohen's and I think you're right. So I'd also ask the court to grant, to reverse and grant our petition on the motion to dismiss. The state did not specifically traverse the issue of consent. They came up with this new idea that there is a scope of consent. And as to
So your one argument is the state doesn't need it, and the other argument is there's not enough evidence, so you should dismiss the case?
well,
That's what it sounds like.
the motion to dismiss was that Mauricio consented to it. And the state came and said, well, he conceded a part of it, but there's this scope of consent, and therefore the jury should determine scope of consent. We don't think that cuts it, and that should be reversed. And then as far as the other part, they talk about in their traverse regarding the incredible amount of force that was used to cause these injuries could only be deemed intentionally causing harm. That's supposition. It's not specific facts. So from a technical standpoint, the judge should have granted our motion because the state did not specifically traverse it with facts.
Thank you.
Thank you all. Appreciate it.
If I could briefly address what was said about the 403 issue, there was no 403 analysis. This is a misapplication both of Scarborough and this is a misapplication of TB. TB says evidence of an injury.
What about the argument that the question my colleague had, that at the hearing, the state attorney said, oh, we have the evidence we need. In other words, given the standard of review, how does this substantially impair the state's ability to prosecute the case?
Because we need to establish bodily harm. We need to establish culpable negligence, and we need to establish injury. One thing I should have said before is that the defense cannot stipulate its way into forcing the case, the state to prove its case a certain way. The old chief issue, in which the court said that if a defendant stipulates, the state doesn't have to accept that. The state should still be able to prove its case by the means it desires. The fact that the defendant is willing to stipulate doesn't mean the state has to accept that and has to say, okay, well, you have stipulated to, say, personal injury, or you have stipulated to bodily harm.
But why isn't the fact that you have all these witnesses who saw what happened, who saw how hard he hit him, who saw him hit the floor and get knocked unconscious? I mean, this is a subtle issue, but that you have enough to prosecute, which I know would not get a reversal on a direct appeal by a defendant. The case law is crystal clear generally that you don't win a direct appeal by a criminal defendant when you argue, oh, they brought too much evidence in, they didn't need to bring it in. But this is your petition, your burden to show, Judge, Your Honors, we cannot prosecute this case in a reasonable manner without this evidence.
We have to show intent. We have to show his intent to do this. The extent of the injuries proves what he did, and it proves his intent, and it proves that he acted with culpable negligence. Intent is rarely, of course, proven by direct evidence. It's proven by the surrounding circumstances. And as I said
Which
before,
the ASA admitted at the hearing that they had circumstantial evidence to prove the force.
But
All the witnesses is what he said. All the witnesses will say that he hit him as hard as he could.
if they testify, if the jury believes them, we want better evidence. We want the physical evidence. We want the scientific evidence. The
state wants that, wants a better case, wants better evidence to
the highest
present.
burden.
Sure. But how is that? So we're looking at a miscarriage of justice. Is there a miscarriage of justice in this case? Is there some sort of serious defect in the proceedings that justify us intervening, which is an extraordinary act by a DCA?
Yes.
And it's discretionary
Yes.
on top of that. So
Discretionary
what
and
is the
extraordinary.
what is the best argument for the state, compelling, that despite what the evidence is that the state did have, that it's severely impaired from presenting its case without the medical records that have been excluded, based on this defect in the proceeding in some way?
Well, as a practical matter, first, there's no guarantee that these witnesses appear for trial. There's no guarantee that happens all the time in trials. There is no guarantee that they keep their story. There's no guarantee that they won't be impeached. There's no guarantee about anything with witnesses. The best evidence is physical evidence. The best evidence is scientific evidence, and that is played out in trials every day.
So you have doctors on tap as well, guaranteed to testify at that trial?
The state attorney said that he did intend to have a doctor testify yesterday.
Well, he also said he intended on bringing in all these witnesses from around the country.
Intends.
Sure.
And if I can add that this was April of 2018, and where are they now? Maybe they can't come. We need this evidence because it shows intent, it shows bodily harm. The extent of the injury, it proves what happened. Without it, an injury alone means nothing. An injury could be this small cut on my finger. An injury could be a cracked skull. It could be subdural hemorrhaging. The injury alone proves not a thing. They would not know what happens, and of course the final element I think the state does meet quite clearly because the state would have no adequate remedy on appeal. And what I've said about the first element, the essential requirements of law, this was a clear, this judge simply
Well,
applied the wrong law. with
You
respect to
both had your
Scarborough.
time extended. I'll ask you to briefly conclude,
Oh, one more?
very briefly.
Well, that was my last.
You want us to grant the writ? I'll do it for you. Thank you. The court's in recess.
All right.
Honors.